Excuse me for a moment. I am patting myself on the back because I am good. Perez Adamas called it again. Hello, my fam. It is Perez, the queen of all media, the original influencer, and your number one source for everything It Ends With Us saga. Team Baldoni has wasted no time already responding to the motion for sanctions filed by Amber 2.0 earlier today. Sexual harassment Barbie went crying to Judge Lyman today, arguing that Melissa Nathan, Jen Abel, Jamie Heath, all of the Baldoni parties filed false complaints against her. No validity to them. They were not tied to it whatsoever. There should have been no group filing, etc., etc. Watch my video on that from earlier today to get fully caught up. Additionally, the yummy and sexy and flirty Chanteuse said that the Baldoni parties are clogging up the docket, purposefully delaying things and causing her to spend more money unnecessarily. What did I say? What did I tell you all when I made my video about this? I said, projection, mirror. You are doing all of these things. And that's exactly what Team Baldoni is now arguing. It's also interesting to note this letter to the judge was filed today, but dated May 13th. Meaning the Another Simple Extortion star is playing checkers, but Brian Friedman, his attorney, is playing chess. How do the Baldoni parties respond to the motion for sanctions, including they want the Baldoni parties to pay for all of the attorney fees incurred recently? Team Baldoni says, the following is the Wayfarer plaintiffs' consolidated response to the 12 Rule 11 letters, collectively the letters, directed to each of the Wayfarer plaintiffs by your clients, Blake Lively and Ryan Reynolds. The letters address alleged pleading defects that the Lively defendants have already placed before the court in their respective motions to dismiss the first amended complaint. That's what I said. I'm so freaking good. I literally said that. Literally. The gist of the letters is that the first amended complaint's extortion, defamation, and intentional and negligent interference claims are stated on behalf of the Wayfarer parties as a group and do not state facts sufficient to state a claim on behalf of particular plaintiffs swept into the definition of Wayfarer parties. For instance, the Lively defendants threatened sanctions against Jamie Heath on the asserted grounds, his producing partner, that Mr. Heath lacks standing to assert an intentional interference claim because the first amended complaint does not allege that he is a party to the allegedly interfered with WME contract, the agency that he was dropped from, and the agency that his company, Wayfarer Studios, was dropped from. The same company that Jamie Heath is the head of. I see a direct correlation there. The Baldoni party's letter says, the first amended complaint, according to Team Delulu, fails to plead specific defamatory statements about Mr. Heath, but does so only about others included in the term Wayfarer parties. As another example, the Lively defendants complain that Melissa Nathan, his crisis PR expert, is grouped under the umbrella of Wayfarer parties in the first amended complaint's extortion claim, even though only Wayfarer, Heath, and Baldoni are proper plaintiffs. The Lively defendants also object that the first amended complaint's false light claim is properly stated only by Baldoni, Heath, Abel, and Sarowitz, and not Melissa Nathan. Simply put, listen up. Group pleading is the defect at the heart of the Lively defendants' Rule 11 letters. I went over Rule 11 in that video. Watch that to be fully caught up, as I said. Such purported pleading facts, says the Team Baldoni letter, particularly those already before the court in a motion to dismiss, as they have already submitted a motion to dismiss, are not the proper subject of a Rule 11 motion. Let me repeat that. Such purported pleading defects, the faults they claim in the first amended complaint, particularly those already before the court in a motion to dismiss, are not the proper subject of a Rule 11 motion. In fact, such motions are improper if they are substantially identical to the arguments made by defendants in support of their motion to dismiss for failure to state a claim. I literally told you all they were the same regurgitated claims as her motion to dismiss. Then they cite case law supporting what they say. Rule 11, blah, 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 should not be used for this. The lively defendants' Rule 11 arguments are not merely substantially similar to, but the same as arguments asserted in their motions to dismiss. And a reminder, her husband has also filed a motion to be dismissed too. The Baldoni party's letter continues, even ignoring the awkward fact that Rule 11 does not apply, group pleading is a common practice, as expressly stated in the responses to the lively defendant's motion to dismiss. If the court deems this definitional issue to be a pleading defect, it is easily curable by amendment. A curable pleading defect does not rise to the level of frivolous, legally unreasonable, or factually without foundation as required for Rule 11 sanctions. Put another way, if the court grants your client's motions to dismiss in whole or part, the Wayfarer plaintiffs will amend the first amended complaint as directed by the court, obviating any imagined Rule 11 issue. If the court blesses the pleading and denies your motions to dismiss, any Rule 11 motion by your clients would be rendered frivolous. Indeed, the Supreme Court has recognized the flexibility provided by Rule 11, allowing pleadings based on evidence reasonably anticipated after further investigation or discovery. Then they cite and elaborate upon the Supreme Court ruling, blah, 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 blah. Finally, oh, this is so good. The letters cynically quote Mr. Friedman, his lawyer, whose statements are not pleadings filed with the court and are thus outside the ambit of Rule 11. Since they have no relevance to Rule 11 sanctions, the only conclusion to be drawn is that the inclusion of the statements in the letters has no purpose but to harass and undermine Mr. Friedman and our firm with the court, the very conduct sanctions seek to curtail. In sum, this is so good. The lively defendants' 12 letters claiming that the Wayfarer parties have violated Rule 11 are in themselves frivolous and contrived solely to harass and increase the cost of litigation. I know you are, but what am I? Such hardball litigation tactics, including threats of Rule 11 sanctions, are improper. See Guidardo versus Ethel Corp. Okay, I got to the end and I realized I had a brain fart at the beginning. So to take it a step back, this was an email sent to the Floral Fanatics lawyer last week. The Baldoni parties saw the motion for sanctions today coming a while ago. This is their response, but not their official response submitted to the court. This is what they told them last week. So when we get their official response, it'll probably be echoing everything that I shared with you in this video. Understood? We're all learning a lot about the law together. All right, thoughts? Let's discuss in the comments section.